Number 8, making your agent a joint owner of your bank account. There's a lot of reasons for this confusion. People think that if I just put somebody on my bank account, I don't even need a power of attorney. And there's reasons why you might think that. I mean, it makes sense. If you make somebody a joint owner on your bank account, they own it with you. They have all the rights that you have. And by doing that, they can transact business. They can withdraw money, they can put money in, they can do all sorts of things. So it's kind of like in lieu of having a power of attorney, people say, well, I just will make this person who will transact business for me, my child or whomever, a joint owner on my bank account. The reason that's a really, really bad idea, especially if we're talking about any sum of money beyond just enough money to pay for funeral expenses, is that it's their money too. You've made them a joint owner. You've made them a gift of this money. If they have a divorcing spouse, if they cause a car accident and they don't have enough liability insurance, if something happens where somebody sues them, they have creditors, they come after them, that bank account that was yours and is your money now is going to be susceptible to those creditors' claims. And you'll have to defend against that to say, oh no, it was my money. I didn't intend to gift money. It's really not their money. The whole idea with doing good estate planning documents is avoiding having to argue and fight in court about what should be. Your durable power of attorney says what should be. If you make somebody a joint owner on your bank account, you've thrown confusion into everything. So I don't recommend that you do that. Another reason not to do that is upon your death, the joint owner, let's say you had 3 kids and the joint owner, you said, well, you had 1 kid as a joint owner, said, please divide it with, your siblings when I'm gone. They go, of course I will, Mom. What happens when you're gone? Well, that joint owner might have been the one who took care of you, who helped you with everything and did all this stuff with you. And they say, you know what? My siblings didn't do anything. They really don't deserve anything. So I'm going to keep it. And then litigation will result. And then it'll be for the court to determine who really should get that money. So don't make that mistake. Don't make your agent under a power of attorney a joint owner of your bank account. One of the things that be careful of is when you go to the bank, they might say, oh, just do it this way. Just make them a joint owner. And be careful where you get your legal advice. Don't get your legal advice from the bank. Don't give your legal advice from your accountant, your financial advisor, at least when it comes to what your estate planning documents should look like. See an attorney, because everybody is willing to give you free legal advice, except for the attorney. We charge for our legal advice. So be careful where you're getting your legal advice. Another reason people might think that they don't need the power of attorney is because, let's say that they're married, and that means your spouse is a joint owner on your bank account with you, and you don't have a power of attorney. And so why would you need one? I mean, you're married, Washington and Idaho, they're community property estates. Why do we need a power of attorney? Well, what I like to say to clients is, have you ever thought about the time you try to call on your spouse's credit card and they say, oh, I can't talk to you, put your husband on the line or whatever? You need a power of attorney even if you're married, and a lot of people don't realize this. You have joint ownership of your house and on your bank account, so you don't think you need a power of attorney. But think about this, when you sold your house or bought your house, your spouse needed to sign just like you did. If your spouse can't sign for any reason, how are you going to sell your house? How are you going to buy your house? You can't. There'll need to be a guardianship if that person, your spouse, has lost capacity, and you need to transact any type of business like that. So people are surprised to learn just because you're married doesn't mean you can transact business for your spouse. You can't unless you're a joint owner, like on a bank account, but that does not work for real estate.